Good. Yeah, cool. Okay.
Hello, fellow Facebook friends, and welcome to Legal Live, where we discuss your legal concerns with the Tom Riley Law Firm in Cedar Rapids. The following is a paid sponsor segment, and the thoughts, questions, and beliefs are those of the Tom Riley Law Firm and not of KCRG, TV9, nor Gray Television. During Legal Live, if you have any legal questions, please comment down below now, and we'll get to as many of your questions as we can. We're visiting with Peter Riley, who's here to help you. As always, we'll begin with a couple of great questions from our last segment. And Peter, the first question comes to us from Jenny, who asks, can a finalized adoption be contested later on? Asking for a friend. Her teenage daughter gave birth and her parents legally adopted her, as the teenager was not capable and into drugs, etc. Now, the birth mother, the teenager, thinks she can legally get the child back.
Well, adoptions are always, can raise sad situations, particularly when there's a change of mind. But that's not the only time that there can be problems with that. Basically, if the adoption is done properly, and there is notice given to everyone who has an interest, then it is a final court judgment and it can't be changed. But it's got to be done right. And some of you may remember back in the early 90s, we had this case involving baby Jessica. And a woman had decided to put her child up for adoption, but she basically lied as to who the biological father was. And then the biological father found out, and he came in. And this nice couple from Michigan had adopted this child, raised his own because they couldn't have children. And suddenly the birth father, the true birth father, comes and says, "Wait a minute, I didn't get notice." And he ultimately prevailed.
Wow.
And that's really, at the time I figured, well, he is, and he wasn't given notice, not his fault. And there was a lot of stuff in the media. They tried to make him out as a low life, and he wasn't maybe the most respectable citizen, but nonetheless, he was the biological father. He's entitled to notice. And so if it's done right, it's a final judgment, and you can't set it aside or change your mind. But you have to give notice to everyone.
Seems fair to me.
Yeah. Well,
hey, we just got a brand new question, Peter, from Beth. And Beth asks, what should I do if I don't have a trusted executor of my will for finances and health? I think I can hire someone. What do they typically charge?
that's a good question, but let's talk about terminology, because I think what she's really looking for is basically someone to act under a power of attorney. The executor of a will doesn't assume any authority until after the person who makes the will dies.
Right.
And the will is admitted to the court system through probate. And if you don't have, I remember, from law school, Sheldon Kurtz saying, if you don't have an executor, like everyone you named is gone, the court will always find someone, okay? It sounds more like the question is getting someone to act as a attorney, a power of attorney. And what she probably should be doing is thinking about doing a revocable trust and naming a backup. There are a number of banks that do a very nice job of acting as fiduciaries. They would prefer, like in Iowa, in an estate, the standard fee, which is basically, a maximum for ordinary services, but 2% of the estate, and they like to get that. But there are many that will charge by the hour to do that. So I think what she should do is go to a bank, and don't go to the biggest banks. Go to a small locally owned bank. See if they have a trust department. Talk to them, and tell them you'd like to set up a revocable lifetime trust, and have them a backup trustee if you're no longer able to take care of your things, your affairs.
Very good. Beth, if that answers your questions, please let us know. If not, if you've got further questions, put them in the comments section below, and we'll get to it right away. And thank you for submitting that question to us. If you're just tuning in, you're watching Legal Live with Peter Riley from the Tom Riley Law Firm, and he's here to help you. If you've got a legal question, put it in the comments section just like Beth did, and we'll answer it right away. Peter, we're moving on to our next question. It comes to us from Philip, who says, my adult daughter in Cedar Rapids is being asked to give witness testimony in a criminal trial in Florida, where she used to live. But she just started a new job. The cost of flying to Florida, staying in a hotel, and boarding her pets is a great burden, and her new employer won't tolerate her being gone for a week. Is she able to give a video testimony in this case?
That is a potential option, although there is a complication with respect to a criminal case. So the first thing you have to look at is, is there jurisdiction to issue a subpoena? Now, in the federal system, there's a federal court in every state, so they can get people and subpoena them under the federal system. In a state system, the state of Florida can't issue a subpoena that is enforceable outside the state of Florida. There is basically an interstate compact situation for criminal cases because you're going to need testimony from people who are witnesses to a crime don't always stay in the state where the crime was committed, so you're going to need out-of-state witnesses. And so under the procedure, basically the state where the prosecution is taking place requests this issuance of a subpoena in the state where the witness is, and then the witness has a right to be paid expenses and all that, and reimbursements. And one thing to keep in mind, if you're ever subpoenaed for a civil or criminal case in Iowa, you have a right to ask for your mileage and witness fee, $5 or $10 a day and $5 a half day. But you have a right to ask for it. And if you don't, if you ask for it and you're not given it, subpoena service is not valid. Keep that in. That's a little.
Is the same hold true for out of state or for flying?
For any Iowa subpoena, you can ask for your fees. Now, when you've got this out of state case, because of the expense involved, there is an issue about being able to get reimbursed for your expenses. The idea of a video testimony, which is becoming more and more common, and COVID really made it very, very common, that may work, but with one exception. In a criminal case, the defendant accused has the right to confront their accuser. We just had a Supreme Court decision in Iowa about whether the children who testify in abuse cases can do so remotely, and ultimately the Supreme Court said no, and that's contrary to the right of confrontation. So if you're the victim, you're going to have to be there.
It says here in his question that it's witness testimony.
Right. I mean, if it's a witness and not the victim, you don't have the obligation to be a physical presence.
Okay.
But I think that's really an option. And if talking to the prosecution's office doesn't help, get a lawyer. But the expense of transporting somebody to Florida versus doing it by a video or a live Zoom hookup, is certainly an option.
Yeah, I would think so.
So I would look into that, and again, get a lawyer if you're not if they're not being willing to work with you.
Well, it is Florida.
Yeah, well, I mean, maybe you could schedule the time and get down there when you want to. But seriously, that's the thing. You can't expect people to have to put up with hardship, and you're always entitled to your expenses.
Yeah.
Now, the witness fee is not very great, so there's not much. You won't be out of pocket, but if they really need you in person, they can compel you to do that. And if you disobey the subpoena, sheriff will come over and put you on a plane.
Yeah, there's a way to get there.
Yeah,
Well, Philip, that's a great question and one I'd never considered before, and we appreciate you submitting it. Peter, we just got a new question from Chad, and Chad wonders, do you have any legal services for VA service claims?
We don't handle the VA service claims. There are people who do that. All of these, just like Social Security and and other federal claims, it's kind of a niche field, and because there's a lot of things you have to learn about to do it, and the approved fees are not very significant, so you really have to do it on a volume basis. But just, Google, VA claims or something like that, and you'll probably get some leads for lawyers that do that sort of thing. Just like if you have a Social Security claim.
Can you recommend a firm?
I'm not sure who does it. I know that there are, some firms where they're veterans, but the safest thing is just go online and Google VA claims, and then start calling. And when you call, ask them a little bit about, what they handle, what their fee base is. You don't have to choose the first lawyer to call either.
Okay. Well, Chad, thanks for the question. And if you've got any follow-up questions, please place them in the comment section now. And speaking of the comment section, we just got another question, Peter. It comes to us from John. And John says, I am a consultant and have a written confirmation of a client's desire to move forward and agreeing to a payment plan. After 6 months in, the client is refusing to now pay. What should I do?
Well, a lot's going to depend on what the contract says, but certainly if you have a written contract that has terms of payment and they're not made, you would have the right to bring legal action, to enforce that. Now, in this case, if the ongoing relationship is, going to pay a lot of money, and you think you might ultimately get paid, you may need to, talk about negotiating something. But basically, if they're just not paying because they don't intend to, or don't have the wherewithal to do it, then you should give them notice. I'm not going to continue to perform until you bring it current. Now, again, that's subject to whatever the contract provides, because if a contract provides for procedures in the event of default or something like that, you have to follow them. But for a general claim, for general contract law, unless there's some specific provision that addresses how you deal with payment defaults, you're free to terminate your services and give notice, and to bring an action for what hasn't been paid.
Yeah, it's got to be very frustrating to have a signed agreement and then not get paid. I think we've all dealt with that in the business world, and it's one of the most frustrating things out there. John, we wish you well. If you've got a follow-up question concerning this, please put it in the comment section now. Peter, we just got another question. It came to us from Marion, and she says, how can my son get a copy of a will, in which he's named as a recipient? The executor won't give him a copy, and the will isn't being probated. He is disabled and low income. Legal aid can't help.
Okay. Right. So the person who made the will, from what I understand the question, has passed away. Okay. But just because there's a will doesn't mean that you have to open an estate. Okay. So for instance, when a married couple comes in for a will, we make them for both couples, but we tell people, and it's been our experience, usually when the first spouse passes away, if the house is held in joint tenancy, so it passes automatically, and most of the other assets do, you don't have to open an estate. Now, in this case, it sounds like, there isn't anyone it's not a spouse situation. You probably would have the right to, if you know what the will says, because again, once an estate's been opened, you have to give notice of the will. You don't have to send the will. You just have to give notice of it, and then basically you're telling people, you want to see what the will says, go down to the courthouse. In this case, an estate's not been opened, but you could bring an action to basically say, I understand I've been named, as a beneficiary, no estate's been opened. They won't give me the copy of the will or provide information, and you're probably going to be able to get a court order to produce the will, and then maybe someone can open an estate. I mean, the preference is always to the named executor, but if the executor won't do it, but you can only really do that if you know that there are assets that are going to be in the estate if an estate is opened, and that's one thing that a lot of people sometimes have a hard time understanding is a lot of property can pass without the need to go through an estate. As I said before, most spouses, the surviving spouse automatically is the owner if they hold property in joint tenants, as almost all married couples do. And there are other things that can be done. But if there is assets that would be in a estate, there are assets, and if you know your name in the will and you're not getting satisfaction, you could ask the probate court to make them produce the will. But again, I'd only do that if you know there's going to be assets there to be available.
I'm curious, why wouldn't an executor give him a copy of the will?
Well, it doesn't make sense unless the executor. There's a couple of options. I mean, number one, the executor doesn't intend to open an estate, and there's no legal reason to, or two, the executor doesn't intend to open an estate, and he's trying to do something funny with the assets.
Yeah, that's what I was thinking.
It really comes down to is there a likelihood that there's enough money to fight over? That's really what it comes down to. Because if you think there's significant assets, you should talk to a lawyer.
Marion, great question. Difficult situation. If you've got follow-up questions, please put them in the comments section now, and Peter will get to it. We wish you well, and we thank you for submitting that question. We've got time for one more question, and this comes from Tommy, who says, I have a medical marijuana card. Am I able to drink a THC-infused beverage in public?
Probably, but not because you have a medical marijuana card. Okay, the statute that prohibits consumption of alcohol in most public places is, by its terms, limited to alcohol. Okay, in other words, laws have to be specific about what's prohibited. It's just like, in California, when LSD started becoming a big thing, it was legal for a fairly lengthy period of time before laws were passed to make it illegal.
Yep.
Okay.
Yeah.
And with respect to the THC infused beverages, a lot of people didn't really understand what that was all about, and probably thought they were just approving CBD, but the law defined CBD to include THC delta 9. So all of a sudden you started seeing the proliferation of THC infused beverages in any state that had opted in, under that program, and under the 2018 Farm Bill was. Well, and some people then have started, Iowa moved to substantially restrict THC beverages. Right. And one thing a lot of people don't realize is representatives or senators from Texas, as a condition of resolving the shutdown last year, insisted language be placed in that will sunset the authority under the 18 Farm Bill for THC-infused beverages at the end of this year.
Really?
Yeah, and it didn't get a lot of publicity, but yeah, so that's potentially on the block, although there is some discussion about writing the bill. The thing is, they didn't anticipate, what was going to happen, and someone didn't think it through.
Surprise, surprise.
Yeah, I remember when I first learned that there were THC beverages, my first thing was, I said, does Kimmy know about that?
Yeah.
and she found out, and the legislature made substantial restrictions.
They sure did.
So, anyway.
All right. Well, we are out of time today, but we'll be back in a couple weeks with another edition of Legal Live, sponsored by the Tom Riley Law Firm, where they know that something shattered can be beautiful again. If your life has been shattered by a work injury or auto accident, reach out anytime to Peter Riley or his partners at TRLF.com. the prestigious Tom Riley Law Firm, where they make families whole again. We'll be back soon. We thank you for watching. We thank you for submitting your questions and look forward to meeting with you again.